Good morning, sir. Can you see and hear us?
Yes, thank you very much.
May I call David Teale, please?
That's in your right hand and repeat after me. I swear by Almighty God
I swear by Almighty God
that the evidence I shall give
that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you. You may sit down.
Good morning, Mr. Teale. As you know, my name is Jason Beer, and I ask questions on behalf of the inquiry. Can you give us your full name, please?
David Sutherland Teale.
Thank you very much for coming to give evidence to the inquiry today, and thank you for the provision of a witness statement addressing the questions that we asked you. Can we look at that witness statement to start with,
Indeed.
please? It's WITN 10550-100. That will be displayed on the screen. I think you've got the hard copy in front of you too. I think there are 4 corrections that you wish to make to your witness statement. The first of which is on page 4. If we can turn to that, please. And 4 lines in, do you see the words a list of productions?
Yes,
Is there an amendment that you would like to make to those 4 words?
that to be deleted.
Thank you. So we can understand the effect of that. You're here talking about the material that you would have received from the post office in the Procurator Fiscal's office in Lochmaddy in early 2009, and you're providing a list of the documents or species of documents that you say you would have received, and you're deleting from that list the list of productions.
That's right.
Thank you. Can we turn, please, to page 7? And the very first line at the top, you're addressing the sentence that was passed upon William Quorm, and you say that he was sentenced to 150 hours community service, and you say reduced from 2,000 hours for a guilty plea. Should we delete one of the zeros?
Correct.
That's just a typo. Correct?
Correct.
Thank you. Do you see the third line starting, it would have been difficult?
Yes, I do.
And then the 9th line ending with the words previous years. Can you see that?
I do.
I wonder whether they could be highlighted. Thank you. Is there an amendment that you wish to make to all of the words between the 2 highlights?
Deletion, please.
You would like to delete those? You were saying in your statement that it would have been difficult, if not impossible, to prove the actual amount embezzled by Mr. Quorm. And you say, given that the Horizon audit depended largely on the bogus figures inputted by him, if the case had gone to trial, you would have had to rely on evidence from his admissions as to how much he considered he'd embezzled and the period over which he considered he'd been operating falsely, and other evidence such as such as average takings over previous years.
Yes.
Why do you now wish to delete that?
On consideration, I just realised that wasn't the case.
You previously thought that proof of the case at trial was reliant on Mr. Quorm's admissions.
That's right.
What caused you to think that proof of the case at trial was not reliant on Mr. Quorm's admissions?
Just once I got into considering it in more depth, as I was mulling it over since I first made this statement in December, I realised that was probably not the situation.
Okay, we'll come to what other evidence there was to prove the amount alleged to have been embezzled by Mr. Quorm a little later. And then is the 4th amendment that you wish to make on page 8. And that's paragraph 19. You're here dealing with Mr. Qualm's interview, is that right?
That's right.
And you say the things that he said, it was difficult to treat them as serious challenges, given that Mr. Qualm admitted taking cash coming into the post office branch. And then the words equivalent of around £4,200 every week for an unknown period, but conservatively estimated to be 10 or 11 months, and without putting it through his till. Do you wish to delete those words?
I do.
Is that because you realise that, in fact, Mr. Qualm did not make such admissions in his interview?
That's effectively right.
So that I can be clear, there should now be a full stop after branch, is that it? And then the rest deleted, the rest of that sentence deleted.
That's right.
Yeah. Thank you.
Is that because you reread his interview and realised that the admissions that you attributed to him there, he hadn't in fact made?
Effectively, yes.
Thank you. With those 4 amendments brought into account, are the contents of the witness statement true to the best of your knowledge and belief?
They are.
And is your signature there on page 12 to attest to that fact?
It is.
Thank you very much. That can come down, the witness statement. Now, Mr. Teale, you're the first Scottish prosecutor that the inquiry has heard from who has been involved in the prosecution of a sub-postmaster where evidence provided by the post office was the basis for the prosecution. I want to ask you, therefore, some questions about the approach that the Procurator Fiscal Service and you took to such cases.
Indeed.
Understand? And I think you're no longer a Procurator Fiscal, is that right?
That's right.
And that role ceased for you in June 2015, is that right?
That's correct, when I retired.
But you remain a practicing solicitor, is that right?
That is right.
In terms of your background, you qualified as a solicitor according to Scots law in 1980.
Yes.
You then went into private practice, is that right? But then in 1982, you joined the Crown Office and Procurator Fiscal Service as a Procurator Fiscal Depute.
That's correct.
In 2000, you were appointed, is this right, Procurator Fiscal for the Western Isles?
Yes.
And does that include the, within its jurisdiction, the Sheriff Court district of Lochmaddy?
That's correct.
And within that jurisdiction was the post office owned and operated by William Qualm situated?
It is.
Can I turn then to your involvement in prosecutions involving sub-postmasters before the prosecution of William Qualm? In your witness statement, there's no need for it to be displayed, you say, over the years, you would have received and considered many reports from the post office regarding criminality by their workforce.
That's correct.
You say that, quote, I found their reports were straightforward and I cannot recall any instances where there was any suggestion that the information provided was misleading. I cannot recall any other post office case considered by me which relied on data from the Horizon system. So are you referring there to receiving and considering many reports about the post office workforce to your many years of experience as a Procurator Fiscal Depute?
Yes.
And was that in busy offices in Glasgow, for example?
Correct.
And Greenock as well?
And Greenock.
With that experience in mind, and also borrowing some of your knowledge on some legal issues, can you help us on these 4 topics? Firstly, the law of corroboration in criminal proceedings in Scotland. We've had described to us the cross-reference is paragraph 4 of the witness statement of Kenneth Donnelly. I think you would know Mr. Donnelly.
I do.
He is presently the Deputy Crown Agent for Specialist Casework at the Procurator Fiscal Office. And he says there must be evidence from at least two separate sources, corroboration, to establish that a crime known to the law of Scotland was committed and that the accused was the perpetrator.
That's correct.
Is that a fair summary?
Very fair.
And so for all of the period that we're looking at, say from 2000 onwards until your retirement in June 2015, was that the position?
Yes.
Would you therefore expect that to be something which was addressed in the reports submitted to you by specialist reporting agencies, including reports from the Post Office?
Yes.
Because if that's the law, it needs to be confronted, doesn't it? It needs to be addressed.
It does.
And just on specialist reporting agencies, is it right that that's a term of art within Scotland? An SRA, a specialist reporting agency?
Yes.
And are there a number of those?
Quite a number.
I've seen a figure of 172 presently. Does that sound about right?
That wouldn't surprise me.
One of those is the Post Office.
Correct.
And so if that's something, the evidence that satisfies the Scottish law of corroboration, that you would expect to be addressed specifically in a report submitted to a Procurator Fiscal, that would be something which you, as the Procurator Fiscal, would wish specifically to address in your decision-making.
Correct.
And so when you're deciding whether to commence criminal proceedings against an individual, you'll want specifically to address the issue of where is the corroborative evidence.
Correct.
Now, although I'm getting ahead of myself a bit here, I think it's right that that issue was not addressed in the report submitted to you in the case of William Qualm.
No, I think it was addressed.
Head on, did it say, we understand that there is a requirement for there to be corroborative evidence, and the two pieces of evidence that at least two pieces of evidence that we rely on to satisfy that test are as follows?
Well, I don't think it said that in these words, but the body of the report indicated that there were two sources of evidence.
Were there two sources of evidence?
From the report, yes.
And what, again, we're getting ahead of ourselves a bit, but just at this point in time, can you identify what the two sources of evidence were?
Yes, there was the audit, the evidence of the shortfall.
And what did that show?
That there was a shortfall of £40,000.
Which crime did that show had been committed?
Altogether, the evidence was...
No, just that one. Which crime did that show that had been committed? The fact that there is a shortfall.
Embezzlement.
So on its own, the fact that there's a shortfall is evidence that there has been embezzlement.
No, maybe it'd be easier if I just explain what I took from the report. Of course, I was looking for corroborated evidence from two sources, pointing A to a crime having been committed, and B, that it was the accused who was the perpetrator. Now, the evidence for both of these came from the evidence that an audit had disclosed a shortfall of £40,000. And the second source of evidence was his admission that he had been taking funds from the post office and using them to prop up his retail business.
And how much had he taken and how?
He'd taken £40,000.
He admitted to taking £40,000, did he? In your mind?
It would probably be easier. It would be easier to look at precisely what he said.
Okay, we'll come to the interview.
Rather than taking it as a generality.
Okay. But in your mind, there was an admission to taking £40,000, correct?
No, the audit had indicated that there was a shortfall of £40,000.
Now, am I right that none of the available documents that you have record contemporaneously what the two sources of evidence that you considered to exist to amount to corroboration were?
Now, I'm sorry, could you repeat that
Yes.
question?
There's no contemporaneous document recording your decision-making on why this was a case that should go for prosecution?
No, you mean my minutes, which I would have made on the case file. Is that what you're getting at?
Yes.
No, there isn't. At least as far as I know, I haven't been presented with any such document.
You mentioned minutes on a case file. At this time, would this have been electronically or would it have been by paper? That you make a minute of your decision-making?
I suspect by paper.
By paper.
This is 2008 we're talking about.
And so would you record, how much of your decision-making would you reduce to writing in a case like this?
Anything that I considered to be important in the decision-making process. Sometimes it's perfectly obvious and you don't have to say anything.
So there would be nothing?
Well, I don't know whether there was anything or not.
No. In such a case where it's perfectly obvious that you don't have to say anything, you would literally write nothing down?
You would just write proceed sheriff summary or proceed by petition or whatever.
And what about a case like this? Would you isolate the evidence in the way that you've just done? There were two pieces of evidence that amounted to corroboration here. They are the shortfall shown at audit plus the admissions in interview, something like that.
Possibly something like that.
But we should be able, if those minutes still exist, we should be able to find a record of your contemporaneous thought process.
There might be something. It seemed to me pretty obvious on rereading it in December of last year what the evidence was to proceed. So whether or not I would have been equally satisfied in 2008, I just don't know.
Can we turn to the second issue I want to ask your assistance on, please? Namely the test that a procurator fiscal applies when deciding whether to commence criminal proceedings against an individual or not. Is it right that that's governed by a document called the Crown Office and Procurator Fiscal Service Prosecution Code, or the Prosecution Code for short?
I don't know if there was a prosecution code in 2008.
I think we got one that starts in 2001.
Okay.
The first edition of it. Was that a document that you would have at your fingertips?
You mean physically or just know what it's about?
Yes, either or both.
Oh, yes, of course.
Can we look at the one that has been provided to us? WITN 1051-0101. Thank you. You can see this was first published on the 1st of May 2001, but it was updated last year in July. And it's not possible to tell which parts have been the subject of amendment between those two dates. So I'm not saying that this was in these precise terms applicable when you made your decision in 2008, but I just want to get your evidence, please, on the test that procurators fiscal applied. If we just look, if we scroll down, please, and look at criteria for decisions. Thank you. In considering the action to be taken in relation to reports of crime, the prosecutor must take account of both legal and public interest considerations. Is that a familiar distinction to you?
Yes.
So is it right that in Scotland too that there were two elements to the test?
That's correct.
Okay. And then under the heading legal considerations, in considering cases, the Procurator Fiscal must decide whether the conduct complained of constitutes a crime known to the law of Scotland and whether there's any legal impediment to prosecution. For example, it may be necessary to consider the effect of any delay, and then something about international law, and then evidential considerations, sufficiency of evidence. The Procurator Fiscal must be satisfied that there is sufficient admissible evidence to justify commencing proceedings. In general, for there to be sufficient evidence, there must be corroboration. That is, evidence from at least two separate sources to establish the essential facts of the case, i.e., that the crime was committed and that the accused was the perpetrator. And then we see reference to the burden and standard of proof. The prosecution must prove these matters beyond reasonable doubt. And then there's a bit about the sources of evidence, and then if we move on, please. We then see that the prosecutor, under these next three headings, before we get to public interest considerations, is directed to consider admissibility, reliability, and credibility. So admissibility, laws of evidence determine whether a court can consider certain types of evidence. The prosecutor will assess whether, having regard to the laws of evidence, the court will allow the evidence to be considered in the case. And then reliability, although there may be sufficient admissible evidence to justify criminal proceedings, consideration must also be given to the reliability of that evidence. This involves an assessment of the quality of the evidence. And then credibility. As with reliability, the assessment of the credibility of evidence is ultimately a matter for the court. However, there may be doubt about the credibility or truthfulness of a witness's evidence, etc. Are those three things, admissibility, reliability, and credibility, things that when you were making decisions as a Procurator Fiscal, you consistently addressed?
Yes.
And on reliability, would you accept that if your case is founded on evidence that's produced by a computer, then it's necessary for the prosecutor to consider the reliability of the evidence produced by that computer?
Yes.
Now, the document then turns to consider public interest considerations, which I'm not going to address with you. What the prosecution code does not do is describe the test that a prosecutor must apply when deciding whether to commence criminal proceedings or not. Do you understand? It says the things you must address are evidential sufficiency and public interest, but it doesn't say what the test is that a prosecutor must apply. What was the test that the prosecutor must apply?
I don't know. I'm sorry, I just don't know what you're saying, what you're asking me.
Well, in England and Wales, a prosecutor is directed, and has been for the last 2 decades, to be satisfied that there is a realistic prospect of a conviction. And the code in England says that a realistic prospect of a conviction is an objective test, and it explains that realistic prospect of conviction means that a jury or a bench of magistrates, properly directed in accordance with the law, will be more likely than not to convict the defendant of the charge alleged. So there's an explanation of the standard that must be achieved in the prosecutor's mind in order to commence criminal proceedings.
Well, that doesn't exist in that form in Scotland.
What test was applied?
public interest.
No, that's the public interest is addressed whether separately in the document, whether, for example, proceeding is in the interest of the victim, the accused, and the wider community, and matters of that sort. I'm asking about the evidential sufficiency part of the test. What test was applied?
There isn't a test as such, as I understand it from what you're asking me.
Well, what approach was taken then?
Well, we look at the evidence. We look at the evidence and judge: is it admissible? Is it reliable? And is it credible?
And overall, is there a compendious approach that you take when you've done those things? I think there's enough evidence to go ahead. I believe there's enough evidence to go ahead. I guess there's enough evidence to go ahead. I think it's more likely than not that the accused will be committed. I'm fairly sure that that's so. I'm certain that that's so. Was there no fulcrum around which the issue turned?
No, you're very much guided by what the report tells you. And in that you assess the quality of the evidence and whether there's sufficient evidence, sufficient corroborated evidence from two sources pointing to the facts that the crime has been committed and committed by the accused.
What I'm trying to probe is it's correct then that in Scotland there was no test that was applied across the Procurator Fiscal Service so far as you are aware that ensured consistency of decision making so that everyone had a datum point past which the evidence must pass in the prosecutor's mind before proceedings were commenced?
No.
What test in your own mind did you apply? I think this case will succeed. I believe this case will succeed. I suspect this case will succeed. I'm pretty convinced this case will succeed.
No likelihood of success doesn't come into the decision whether to prosecute or not.
That was an irrelevant consideration, how likely it was that the evidence was sufficient to establish guilt.
There's some cases that you would take up that you would think, you wouldn't say, I'm bound to succeed in this case, or I'm doubtful whether it'll succeed, so I won't take it up. If they're sufficient and it's in the public interest to prosecute, then by and large, you would take that decision to prosecute.
Very well. That can come down, thank you. Thirdly, can I ask you about... sorry, that can come down from the screen, thank you. Thirdly, can I ask you about computer evidence in Scotland? What was the law regulating the admissibility of evidence produced by a computer before 2015, the year that you left?
I don't know of any such evidence.
You don't know of any such law? Do you?
Law, yes, I beg your pardon.
Is that because you never addressed your mind to it? Or that you know positively that there isn't such a law?
It's because I haven't addressed my mind to it.
You've told us that in a number of cases you considered files that were submitted by the Post Office as a specialist prosecuting agency.
Yes.
Did a number of those rely on computer evidence?
I can't think of any that did.
Other than this one?
Other than this one.
What were the other cases about?
Theft of mail.
So would they be Royal Mail Group cases? So to do with the Post rather than the Post Office?
I suppose if you make that distinction, yes.
And I think you were going to go on and describe some other species of case.
I can tell you that I can't remember any other case which positively relied on computer evidence. I started in Lochmarrie the Western Isles in 2000, and I certainly didn't receive any post office cases between 2000 and 2008.
You referred in your statement to receiving and considering many reports from the Post Office regarding criminality by their workforce,
Yes.
which is in paragraph 6. What was the other cases of criminality by the Post Office workforce?
Well, as I say, theft of mail came into it.
And so was that by postmen as opposed to sub-postmasters?
Correct. I can't remember any other postmaster that I was involved in the prosecution.
Did you, outside of cases involving the prosecution of sub-postmasters, prosecute any other cases that relied on evidence produced by a computer?
I can't think of anything.
And so that would have been from 1982 until 2015? No computer evidence in any of your cases?
Well, all I'm saying is that I can't remember whether there were any or not. I'm not saying that there wasn't.
I mean, in that 33-year period, it's likely that there were some, weren't there?
I don't know.
You don't think that there would have been in a 33-year period a case involving computer evidence?
Listen, I can't remember whether there were any cases involving computer evidence or not.
But in any event, in that 33-year period, you can't recall ever checking what the law was on admissibility of evidence produced by a computer in Scotland?
No.
Can I turn to the fourth topic then, the duty of disclosure? What's your current understanding, obviously we're talking now, but it would have applied to when you were a Procurator Fiscal, of the Procurator Fiscal's duty of disclosure or revelation?
That everything that the Procurator Fiscal receives must be transmitted, must be revealed to the defence.
Do you mean that everything that a Procurator Fiscal receives must be transmitted?
Pretty well everything. I'm being broad, but yes, broad terms.
What's the exclusion then that isn't within the pretty well everything?
I suppose if there was something which was deemed, that the police provided, which was deemed
Sensitive?
correct.
So public interest immunity material.
Correct.
Can you remember and appreciating it's 8 years or so back since you left the PF, can you remember the test, the approach to disclosure that was the law in Scotland?
No, I think things changed in 2010. I think the 2010 Act provided that there was effectively going to be far greater disclosure than there had hitherto been. It was closely regulated following that.
If I suggested to you for the entirety of the period we're looking at, say, 2000 until after the prosecution of William Corm, there was a duty to review all of the evidence and information that the Procurator Fiscal had received. Would that be right?
Oh, yes. Absolutely, I would.
And that you would have to disclose information, even if it would materially undermine or weaken the evidence led by the prosecution,
Of course.
and if it would materially strengthen the accused case.
Equally.
And how did the Procurator Fiscal, in a case involving a specialist reporting agency, go about ensuring that that legal duty was discharged?
Well, they have a duty when they report a case to ensure that they're disclosing to the fiscal everything that should be disclosed.
So you're dealing with the report stage at that point, is that right?
Well, no, I'm dealing with the case as a whole, and
Okay.
yes,
So we're going to come on in a moment to the process by which cases were reported from specialist reporting agencies and then prosecuted. And it seems that there are essentially two stages. One is the submission of a report, and then the documents come later
that's right.
in stage two. Is that a fair, very high-level summary?
That's fair.
At the first stage, that's when the decision to prosecute is made.
Yes,
And so that's taken, we're going to come on to this in more detail in a moment, not on the basis of the Procurator Fiscal looking at the documents. He or she is looking at a report.
correct.
So looking at the investigator's summary of the evidence.
Correct.
At that stage, did the specialist reporting agency owe a duty to reveal to the PF material of the kind that we're talking about,
Yes.
i.e. material that undermined the proposed prosecution's case or may assist the proposed defendant?
Yes,
And so that was something that has to be in the report.
yes,
And then when it came to providing documents to the Procurator Fiscal at the second stage, the later stage, again, was that duty of disclosure one that applied to the specialist reporting agency at that stage too?
of course.
And so it was a continuing duty throughout the life of the prosecution.
Correct. And even after your stage two, throughout the life of the case,
Yes.
that duty,
So right up until trial. I'm not going to come at the moment to duties post-conviction.
okay.
How, in the report stage, was that duty of disclosure as a matter of practice discharged?
It was the reporting agency was under a duty.
That's a restatement of the existence of the duty. So to give you an example,
Yes.
in England and Wales, there are a series of forms that the police service have to fill out, and one of them is specifically in relation to this issue. Was there an equivalent in Scotland?
Prior to 2010, no, as far as I can remember.
I.e. a part of the report or a separate document given over to the identification of material that may undermine the proposed prosecution case or advance that of the proposed defendant.
No,
And so in the reports you got, there wasn't a box, a section, an area of the report that forced the specialist reported agency to address that.
no.
Thank you. Can we look, please, at the relationship with the Post Office? And I just want to try and tap into your long experience as a Procurator Fiscal to hear about the way in which the Post Office and the Procurator Fiscal interacted when the Post Office was acting as a specialist reporting agency. Now, we've been told by Kenneth Donnelly in his witness statement that the Crown Office and Procurator Fiscal Service has been unable to identify any document at all issued by the Procurator Fiscal to the Post Office about prosecutions before the 5th of September 2013. Are you aware of any document, policy, protocol, something written down by which each organisation set out the expectations of the other?
No,
Mr. Donnelly has told us that no specific internal guidance was issued before 2013 that's now been identified, advising how prosecutors were to assess reports and evidence submitted to them by the Post Office. Again, does that accord with your recollection?
Yes, it does.
And so for the 3 decades or so that you were doing this work, nothing was ever written down as to how the Procurator Fiscal is going to address proposed prosecutions by the Post Office.
No.
Now, as we've just discussed, I think it's right that when the Post Office investigator wrote a report to you, I think that was known as a standard prosecution report, is that
Yes.
right? An SPR. And I think after 2006, they were submitted via a web portal, is that right?
Yes.
You've explained that that would not attach the witness statements to it.
It may have, but by and large not.
It wouldn't attach the exhibits or the productions to it.
No.
And so your decision was based solely on what the investigator chose to reveal in the report.
Correct.
Did, to your mind, the investigator have a duty of candour to you in the same way as in England and Wales when one lays an information before a magistrate's court seeking a summons? There's such a duty of candour.
Of course.
In other words, they owed a heightened responsibility to tell you of anything adverse to their case.
Of course.
And so that would ensure, would it, if discharged, that your decision was made in the interest of justice rather than just the interests of the, in this case, Post Office?
Correct.
What safeguards were in place to ensure that the Procurator Fiscal was getting the full picture from the investigating officer in the report?
I don't know if there were any safeguards. It was understood by the reporting agency that they had to have a duty of candour.
They may not summarise all of the evidence, mightn't they?
That's a possibility that they might not, yes.
They might mis-summarise the evidence.
Correct.
They might not fully summarise what an exhibit or the exhibit showed.
Correct.
They might mis-summarise what an exhibit showed.
Correct.
They may not summarise what happened in the interview.
Correct. Properly, yes.
Sorry?
They may not properly summarise what happened
Yes.
in the interview, yes.
I.e. getting over to you the full nuances of what happened in an interview.
If there were vital nuances, correct.
Yes. You wouldn't have any means of knowing that.
At that early stage, no.
So you would have to take it on trust that everything was being done correctly by all investigators in all cases.
At that stage of report, yes.
Were the Post Office cases directed within the Procurator Fiscal's service to one specific team to consider?
Not in the sort of offices that I worked in, which are remote and manned really just by me.
So they were they weren't all directed to a central office. They were spread across whichever jurisdiction the Procurator Fiscal covered according to where the branch was situated.
Yes.
Okay. And so there wasn't a process of allocation, that just naturally followed jurisdiction, is that right?
Correct.
And so there wouldn't have been, is this right, any sort of cross-sharing of information within the Procurator Fiscal about issues or problems that the Post Office cases may have presented?
No.
Do you recall taking cases involving sub-postmasters before the introduction of the Horizon computer system in 2000?
No, I can't recall.
And I think you told us that the only one that you took post-2000 was this one, William Quorm.
Correct.
How would you describe the Procurator Fiscal's relationship with the Post Office when it was acting as a specialist reporting agency, so far as you could see from your, as you said, quite remote jurisdiction?
Yeah, it was fine.
Would you take any steps to interrogate the suggestions and findings presented to you in a Post Office investigator's report?
You mean the SPR?
Yes.
I could, yes.
Would you ordinarily engage with the investigation manager at the Post Office in a dialogue? This is pre-decision to prosecute.
Yes, I could and would if it was necessary.
And what might make it necessary?
Lack of clarity.
Would you typically go back with questions or ask for further inquiries to be conducted?
Well, when you say typically,
Yes.
I've said that I hadn't had any cases between 2000 and 2008. So typically it's quite a difficult question to answer.
What about the cases involving the post rather than sub-postmasters?
They're the 90s, 80s, I can't remember.
Did you ever engage with anyone other than the investigation manager within the Post Office?
Not that I can remember.
Taking your evidence on this as a whole, would it be fair to say that you worked on an assumption that the Post Office investigator had pursued all reasonable lines of inquiry, including those that pointed away from the guilt of the accused, and had fully and fairly summarised all of the witness and exhibit evidence, documentary evidence, in their report?
Yes, of course.
And you took that on trust?
Yes.
Within the last couple of weeks, Mr. Donnelly has made a public statement on behalf of the Procurator Fiscal Service in relation to the Horizon cases that were prosecuted in Scotland. And he said that the estimation of the service is that up to 100 cases involving Scotland may be affected, and that is a lower number than in England and Wales due to the Procurator Fiscal's policy decisions made in a response to awareness of Horizon system issues. Before 2013, were you aware of any, what he describes as Procurator Fiscal policy decisions made in response to awareness of Horizon system issues?
No.
When did you first learn of possible issues or challenges to the accuracy of Horizon data?
I can't recall, I'm afraid.
Can you remember how you learned it?
Equally, I can't recall.
Was it before or after you left the service in June 2015?
I can't recall.
Were there communications within the Procurator Fiscal Service before you left in June 2015 in relation to the accuracy and reliability of Horizon data?
Well, I personally can't recall. That's not to say that there weren't. I know that the Lord Advocate addressed Scottish Parliament recently on the 16th of January, and I think she said in that Procurator Fiscals were advised by Crown Office to desist from prosecutions.
In 2015?
I can't remember the dates.
Yes, we'll come to that in a moment. I'll give you a bit of detail to help
Okay.
On that. But at the moment, from your memory, can you recall whether any announcement was made before you left in June 2015
I can't remember.
by the service to all Procurator Fiscal deputies For example, making them aware of possible issues with the reliability of Horizon data?
Well, I can't remember.
What about the other way round? Were you ever asked by the service of your experience of reviewing cases? It would have been limited, I think, to Mr. Qualms.
No.
Can we look then, please, at WITM 1051-0100? This is Mr. Donnelly's statement to the inquiry, the relevant parts of which were read into the inquiry record earlier. And I'm just going to use this as a basis for asking you some questions about these issues rather than what the Lord Advocate said to the Scottish Parliament on the 16th of January. If we can go to page 13, please. And paragraph 43. I should say that this is a statement made on behalf of the service, the Procurator Fiscal Service. And Mr. Donnelly, on behalf of the service, says that between 2000 and 2013, the Procurator Fiscal Service was not institutionally aware of the bugs and errors in the Post Office Limited Horizon system that significantly impacted the reliability of evidence submitted by the Post Office. And then paragraph 44, he says on the 14th of May, at that time, 14th of May 2013, you would still be employed. Is that right?
Yes.
Post Office, via their Scottish agents, BTO solicitors, contacted the Procurator Fiscal Service to request a discussion about issues with the Horizon Online system. On the 29th of July 2013, solicitors for the Post Office explained to the Procurator Fiscal Service that as a result of the Second Sight and Helen Rose reports, Post Office Limited had instructed their solicitors Cartwright King to carry out a review of all cases reported against sub-postmasters and mistresses, dating from the rollout of Horizon Online in January 2010, in cases where a sub-postmaster had raised an issue with either Horizon Online or their training of the system. Both the Second Sight and Helen Rose reports were being disclosed to the defence by Post Office Limited. BTO solicitors then advised the Procurator Fiscal Service that it would be reviewing all the Scottish cases that could be affected by the issues identified in these two reports. On 9th of August 2013, the Procurator Fiscal Policy Division made senior Procurator Fiscal Service officials aware of the developments and asked that information regarding the issues with Horizon Online be passed to prosecutors dealing with ongoing reported cases. So in summary, Mr. Donnelly is telling us that in 2013, Post Office solicitors told the Procurator Fiscal Service about some challenges around the Horizon evidence. Yes?
Yes.
You were not, I think, present in any of these meetings. Were you told about the fact that they were taking place or the issues that came out of them?
Not that I recall, no.
Were you told about the Second Sight review?
No, not that I recall.
And the Helen Rose report?
No.
And the last sentence, the policy division made senior officials aware of the developments and asked that information regarding the issues with Horizon Online be passed to prosecutors dealing with ongoing Post Office reported cases. Did that happen to you?
I can't recall.
Okay. Were you in fact in 2013 dealing with an ongoing Post Office case or not?
No.
You weren't? Okay. Were you aware of the instruction of BTO solicitors in 2013?
No.
Can we move on, please, to paragraph 45? if we just scroll down, we're moving to later in the year in 2013. On the 5th of September, a meeting took place between the Post Office, BTO solicitors, that's the Post Office's Scottish solicitors, Cartwright King, that's their solicitors for England and Wales, and Crown Office Policy Division officials at the Crown Office in Edinburgh. Cartwright King's senior counsel, Simon Clark, was in attendance. At the meeting, BTO solicitors explained that it had carried out a review of all live Scottish cases and had determined that the Horizon system defects identified in the second site and Helen Rose reports did not play a part in any live Scottish cases, save for one. BTO's review processes assess cases as Type A or Type B. Type A, in which Horizon had provided the information as to wrongdoing, but was not the provider of primary evidence. In almost all of these cases, the sub-postmaster had admitted to the taking of monies belonging to the Post Office for their own unauthorised purposes. Type B, where Horizon or the training of its use had been raised by the sub-postmaster. Cartwright King and BTO solicitors advised that only Type B cases were cases which, in their view, required disclosure of those two reports. BTO's review concluded all but one live Scottish case was Type A, and that all concluded cases were Type A cases, which did not necessitate further review or disclosure. Was that communicated to you that this distinction between cases existed, that they were to be treated differently?
Not that I can recall, no.
And you didn't have a case on your books at the time?
Correct.
You can't recall any memorandum or edict coming out from the centre about the treatment of a Post Office case if one was to land on your desk?
No.
Okay. Were you equally asked to provide any details of all cases which you had as ongoing?
No, I don't think so.
If we move on to paragraph 47, please. Post Office Limited advised the Procurator Fiscal Service that a full examination of the Horizon system would be undertaken and would be completed within 6 to 8 months. I take it that kind of information wasn't fed down to you either?
No.
And paragraph 48, in the light of these revelations, an instruction was thereafter circulated within the Procurator Fiscal Service for prosecutors to consider Post Office reported cases on their facts and circumstances over the page in determining whether they should be adjourned pending the outcome of Post Office review. The Procurator Fiscal Service did not terminate all Scottish Post Office cases. Can you remember that kind of instruction or memorandum coming out?
No, I can't.
Paragraph 50, ultimately it's understood that Post Office did not commission a second report, as had been discussed. Post Office Limited subsequently advised the Procurator Fiscal Service that despite consulting with academics, a further interrogation of Horizon Online system was not possible. Moving on, paragraph 51, please. 6th of October, there was a meeting. By then you'd left, is that right?
Yes.
So 6th of October, you had left the service by then. I'm not going to ask you about anything there. It seems that up until the point you left, from when the first date that this statement talks about a revelation occurring in May 2013, there was a form of ongoing dialogue between the Post Office and its various solicitors on the one hand and the Procurator Fiscal Service on the other. Was any of that revealed to you as a Procurator Fiscal?
No.
And as I've said, you weren't asked to make a return to establish whether or not you were prosecuting any cases?
Not that I can.
In fact, you weren't. In fact, you weren't prosecuting any such cases then?
Correct.
Okay. The system that was by then in operation, a web-based portal, as I've described it, for submission of reports, I think that had, is it right, a unique identifier for each of the specialist reporting agencies?
Yes.
Would it be possible for somebody at the centre, as I'm calling it, i.e. in the Procurator Fiscal Service, to identify how many cases there were that were being put before Procurator Fiscals by the Post Office?
I can't answer that question.
I'm just trying to understand whether it required positive action by the centre to come out to each of the Procurators Fiscal to find out whether you had a case on your books or whether they could tell from the computer.
I don't know.
You don't know. Okay, thank you. Thank you. Can we turn, please, to the prosecution of William Quorm? That can come down from the screen, that witness statement. I think overall in your witness statement, would this be fair? You seek to convey the view that the prosecution of Mr. Quorm was carried out entirely in accordance with the applicable law and practice in Scotland and raised no concerns for you whatsoever.
That's correct.
And does that remain the case?
It does.
Can we look, please, at your witness statement at paragraph 11, which is on page 4. If we scroll down, it's at the foot of the page. You say, it goes almost without saying that the Procurator Fiscal will inevitably rely on the accuracy of any such report, and there we're dealing with the report submitted by the Specialist Reporting Agency to the Procurator Fiscal, inevitably rely on the accuracy of any such report on which to base his decision. And it's well accepted, he's entitled to rely entirely and absolutely on its accuracy for justification of any consequent actions taken by him. And so that is a reflection, I think, of the evidence that you've given to us already about total and utter reliance on the Post Office investigator. Does that mean that the level of scrutiny that the Procurator Fiscal could in practice apply at the point of deciding whether to prosecute was somewhat lacking?
I wouldn't go as far as that. It certainly got the potential for problems arising if there is lack of candour.
But in England and Wales, for example, police officers produce a summary of the evidence to a prosecutor on a document called an MG5. And many, many prosecutors, indeed members of the bar as well, would say, and indeed are taught, don't rely on what a police officer says the summary of the evidence is. Go and read the evidence. Look at the witness statements, read the exhibits, read the documents, see for yourself what the evidence actually shows. Not rely on somebody who might have a vested interest in presenting a rosy picture, might say. That was an impossibility for you at the point of prosecution.
At the point of raising the prosecution, it's not an impossibility, because if there was some doubt about any aspect, you would of course go back to the reporting officer and ask for clarification.
That's only if the way they had written the document
That's, I beg your pardon?
That would only be if the way they had written the document raised an issue.
Well, no, it might be apparent by virtue of lack of saying something.
You continue, if there were ever any concern by a reporting officer in any agency, whether the police, the DWP, the SSPCA, I think that's the Scottish Society of the Prevention of Cruelty to Animals, or Post Office, that any part of their report was open to doubt, then that should be brought to the attention of the Procurator Fiscal in the body of the report. Is that the safety net then? Is that what you're describing there?
Yes.
And so have I understood this correctly, that it places responsibility on the author of a document to identify anything in his or her document, if there is anything in that document that their writing isn't accurate or open to doubt?
They should make the fiscal aware, yes.
Are they the best person in the world to identify whether what they're writing might be inaccurate?
Well, I can't answer that, but that's what's happened.
You continue, if in any if in this case there had been any doubt as to the accuracy of the data produced by Horizon known to the reporting officer, then of course that should have been made very clear, since it would have seriously affected the decision made by the Procurator Fiscal. Can I understand what you're saying there? It appears to be that doubt as to the accuracy of the data produced by Horizon had to be shown before the accuracy of the data produced by Horizon needed to be checked.
Give me that again, please.
Yeah. Is what you're saying there that doubt as to the accuracy of the data produced by Horizon had to be shown before the accuracy of the data produced by Horizon had to be checked?
No, I didn't mean that.
Okay. What did you mean?
I meant that if the reporting officer had known that there was some doubt generally about the accuracy of the Horizon system, then that should have been the sort of doubt that came to light later on.
I see. If you were relying on data produced by Horizon, or a document which is made up of data produced by Horizon, or an analysis which relies on documents produced on the back of data produced by Horizon, like an audit, to prove that a loss had occurred, to prove that certain transactions had been conducted by a sub-postmaster, wouldn't you have to establish the accuracy and reliability of those data in any event?
Well, when you say at what stage are you talking about? Are you talking about the reporting stage?
Yes. Remembering the prosecution code, which says in deciding whether to prosecute, you must have regard to admissibility, reliability, and credibility. On reliability, if you're relying on data produced by a computer to prove a loss, to prove transactions, don't you have to establish the reliability of those data first?
Well, I think you're entitled to expect that the reporting officer will have satisfied themselves as to the reliability. In the same way that you accept the evidence from a forensic science laboratory that their DNA analysis is accurate and hasn't been tainted. In the same way that you expect a police officer who's operating a speed gun to be satisfied that it's operating accurately. There are certain things that at that stage you simply, almost as a matter of course, accept.
So you'd proceed on the basis of an assumption that the computer was operating properly?
Yes.
But if somebody, a suspect, the defendant, had said the system is not working properly, would that be sufficient to trigger what you speak about in paragraph 11?
It would certainly trigger concerns in my mind.
You go on later in your witness statement to say that no Horizon ARQ data was sought in this case.
I didn't seek it.
Yes, I mean, I think what you say, I've been asked, this is paragraph 24, I've been asked whether any Horizon data, and in particular ARQ logs, was requested from Fujitsu in this case. No Horizon data was requested from Fujitsu.
By me, no.
Or by anyone, so far as you're aware.
Well, I'm not aware of that. By me.
Right. Have you seen any positive evidence, even now, that Horizon ARQ data was sought by anyone?
No, I haven't seen any such evidence.
Okay.
But that's not to say that there hasn't been. I just haven't seen it.
Well, we've heard from Mr. Teale and Mr. Grant, the investigators, and they've told us from your chair that no such data was sought in this case.
That's fine.
So let's work on the basis that no ARQ data was sought.
All right.
Were you aware of the facility to ask for ARQ data?
No.
Were you aware of even if you didn't know that it was called ARQ data, were you aware of the facility to ask for information, material evidence, to establish to some extent whether transactions conducted in a branch were attributable to a sub-postmaster?
Sorry, go back to the beginning of that question.
Were you aware, when you were prosecuting this case, of the facility to ask for information, for evidence that would establish to some extent whether transactions conducted in a branch were attributable to the sub-postmaster?
No, I wasn't aware as such, but I was aware that if I need to find that information, I would have asked the investigating officer.
What about this? Were you aware of a facility to find out information, to get data, to see whether any system faults had occurred that were material to the transactions that had been carried out or the process of balancing?
No.
Were you aware of something called the Horizon Help Desk?
No.
And so I think it follows that you weren't aware of the facility to ask for Horizon Help Desk records.
That is correct.
And similarly, a body called the National Business Support Centre, the NBSC. Were you aware of that when you were prosecuting this case?
No.
And therefore its records about issues that may have been phoned in by a sub-postmaster concerning Horizon or balancing?
No.
Were you aware, was it revealed to you a species of documents called pinnacles or peaks,
No.
which recorded faults or suggestions of faults with Horizon,
No.
that either related to an individual specific branch or to a type of problem or to the system generally?
No.
Okay. And was it revealed to you that there was a species of documents called a KEL, a known error log,
No.
that recorded, amongst other things, known bugs, errors and defects in the Horizon system, and the steps that might be taken or had been taken to seek to resolve them?
No. Remember, that's this stage I'm only reading the report,
Yes.
and I think we've got the report here.
Yes.
I don't think any of that was mentioned.
No.
And if it wasn't mentioned, then I wouldn't know about it.
And I think that applies to the rest of the prosecution as well. All of the categories of material that I have mentioned, ARQ data, records of calls to help desk, records of calls to the MBSC, Pinnacles, Peaks and Kells, they weren't revealed to you in the course of the prosecution at all.
No.
You tell us that the investigation appeared to have been conducted thoroughly and fairly,
As far as I could see at that stage, yes.
and everything was addressed promptly and properly by the Post Office.
It seemed to be, yes.
Thank you very much. I wonder whether we can take a break there, please, until 11:30.
Yes, of course. So
Thank you.
we'll resume at 11:30.
Thank you very much. Good morning, sir. Can you continue to see and hear us?
Yes, thank you very much.
So just before we move on with the questions that I was proposing to ask Mr. Teale, I've been asked to display a document. It's not relevant to the answers that Mr. Teale gave, but should be displayed in any event. WITN 10510-200. It's a second witness statement from Mr. Donnelly. It's dated the 15th of January, and it's a correction to his first witness statement. If we go down the page, please. In the second paragraph, well, the first paragraph, he says, this statement seeks to correct or clarify inaccuracy in my first statement. Paragraph 2, in my first statement at paragraph 46, this is a paragraph that I read to Mr. Teale, I said this. You can see what's there.
Yeah.
And you remember it said that Second Sight and Helen Rose reports did not play a part in any live Scottish case, save for one. And he says the final part of this passage is incorrect. At the meeting, BTO explained to the service that the review of live Scottish cases had determined that the defects identified in Second Sight and Helen Rose did not play a part in any live Scottish cases. It is not the case that BTO advised the Procurator Fiscal Service that one case had been reviewed and the defects identified in two reports had been determined to play a part in the case. And then just read page 2, paragraph 5. The single case had been determined to be a type B case. It's not the position system defects identified. I think there's an error in this correction statement. In the Second Sight and Helen Rose reports impacted this case. Thank you. I don't think that affects the answers that you've given because you weren't told about this at all. Thank you. Can we go back to your witness statement, please? Paragraphs 20 and 21, which is on page 8, please. Page 8. Paragraph 20. You say, at the time of taking my decision to prosecute, and we're here dealing with the section of your statement that concerns Mr. Corm, I think I can safely say I wouldn't have had any doubts as to the reliability of the evidence provided in the Post Office report. And why would you have no doubts as to the reliability of evidence?
Because none were raised by the investigating officer.
And so again, you're relying on this sort of self-policing to fairly to summarise and identify issues about the reliability, credibility of evidence.
Yes.
So there's nothing in there where the reporting officer identifies that there may be an issue with this evidence, or that for example, in the interview, there may be nuances to what Mr. Qualm was saying.
No.
You continue, certainly there was no suggestion that at all that the Horizon IT system had produced or was producing unreliable data. Had there been, I would have seriously considered proceeding further against the accused. And by that, do you mean that if it had been identified to you that the data produced by Horizon, which had been used to produce the audit report, was unreliable or may have been unreliable, you would have considered seriously not proceeding further?
Correct.
We've got some evidence from William Seaton, who I think you'll remember, who was Mr. Qualm's solicitor, a local solicitor, is that right?
That's correct, yes.
Who says in his evidence, looking back, it was assumed that the Post Office IT system was faultless. The Procurator Fiscal's position was the same. He was a bit like, how dare we challenge it, is what he says. Does that fairly reflect your approach to the system at the time? It just wasn't an issue.
That doesn't reflect accurately. That suggests that I was approached by him to say there's something wrong with the system. It can only be the system. And I've refused to listen to him, and that was certainly not the case.
What was your approach to the system then?
What was my approach?
Yeah.
That, as far as I could tell, there was nothing to indicate that it was working, that it was not working.
Did you, so far as you can remember, go through a thought process that I'm relying on an audit report as one of my two sources of corroborative evidence?
Yes.
I need to be satisfied that the data produced by that, relied on to produce that audit report is itself reliable.
Correct.
Where is the evidence of that?
Correct.
And where was the evidence that the positive evidence that the data relied on was reliable?
Well, it would have come from an examination, presumably, of a detail of the audit and a comparison with the bank statements.
And when you say a comparison to the bank statements,
Yes.
had you got those at the time that you made your decision to prosecute?
No.
Were they summarised in any way at all in the report?
I would have to look back at the report, and I'm prepared to do that.
In your witness statement, I don't blame this. Don't blame you for this at all. You refer to a report as being the report that you were sent. I think you know that, that's probably erroneous. That was an internal report to within the Post Office, and that the report that you were sent on the system is a rather different document. Have you now realised that?
Well, I think it was me that brought it to the inquiry's attention.
Right, good, excellent then. So if we look at your witness statement, and if we look, please, at paragraph 9 on page 3. If we scroll down, you say, I've been asked to describe my role in the case. The report from the Post Office was received in early 2009. You say, I read it and considered it. They follow a standard form. There follows a summary of the evidence against the accused over the page. Submitted by the officer in the case, who you expect to have been Raymond Grant, given the contents of the document, and then you refer to the report as Poll 0016 6596. If we can look at that, please. That's the report that you speak about in your witness statement. Can you see that? Yes?
Yes.
That's not the report you received, is it?
No,
That's an internal report within the post office.
that's correct.
And so you never got to see this report,
I never got to see which report.
the one we're looking at.
I think it was part of the bundle, was it not?
When you say the bundle,
Oh, you mean, did I see it at the time of
Yeah.
taking my decision?
Yeah.
No, I wouldn't have seen that.
okay. So we can correct your witness statement when it says, I read the report and this is the report. This is not the report at all. Correct?
That's correct.
Right.
And
So
I
let's look at
didn't-
the report that you did
Well,
get to see.
I have to say, I didn't, when I was writing paragraph 9, I knew that it wasn't the report that I did receive, and I made that clear. And if you look at my paragraph 31,
Yes, got it.
I wonder if that could be shown, which
Yeah, it's on page 11.
that might just explain the position.
Page 11 of the witness statement. You say you don't have access to the papers. Missing is a copy of the case report. It's important because it contains a summary of the evidence. I can only surmise that the summary of evidence would have been roughly similar to the document that we've just looked at.
Correct.
So let's look then at COPF 4002. If we just skip over that page, the second page, and then go to the third page, is that the report that was
Yes.
submitted to you?
Yes.
And is this, if we just go back to the first page, please, in the standard form that by this time, 2009, it's April 2009, the document was received,
Yes.
that they were submitted?
Correct.
And if we go forwards to page 3, we see a summary of the evidence. Go to page 4. The summary continues. And then over to page 6, please. Some branch trading statements are produced, yes?
Yes.
Or referred to. They're not actually produced to you.
Correct. Referred to, yes.
And then at the foot of the page, since the interview, Mr. Qualm has disclosed financial details, and then I think there is a reference to Alliance and Leicester bank statements, Bank of Scotland statements with one account number, a credit card statement with another account number, an RBS statements with another account number, and a loan. And then over the page, reference to some more documents that he has since the interview produced. Because the interview was back on the 7th of August 2008, and this is April 2009.
That's right.
There wasn't any analysis of those documents in this report, was there?
Correct.
And they weren't provided to you.
Correct.
What was your understanding of what was alleged to have occurred in terms of the transfer of money by Mr. Qualm from the post office to either his Royal Bank of Scotland accounts or his Alliance and Leicester accounts?
Well, I wonder if I could just look at the document which I have. Can you identify which number it would be in my bundle so that I can access it quite easily?
You have to tell me a bit more than that.
How do I find the document that you're looking at in the bundle, which I'm holding in my hand.
Oh, right, it's tab E1.
Thank you. I only go up to D35.
We can look on the screen. It's a short document.
It's a what?
We can look at it on the screen. We can scroll backwards and forwards.
It's easier if I can see it in an entirety.
Okay, you can have mine.
Thank you. Thank you. Oh. I've been told that actually I have them, but they're in the shelf here.
Maybe take them out of the shelf and then I can have mine back.
Good.
Thank you.
E1. Thank you. Thank you.
Thank you.
Now, I'm so sorry, but could you ask me again, please?
Yes. What was your understanding of how it was alleged that Mr. Qualm had transferred money from the post office accounts into his Alliance and Leicester and/or Royal Bank of Scotland accounts? The document on the screen can come down for the moment.
It starts at the bottom of... It starts with a paragraph when asked how he removed money from the post office.
So which page of the document?
I beg your pardon. 4.
Yes. So let's display that on the screen. COPF 40002, page 4. And you're referring to the last paragraph on the page. Yes?
Yes.
When asked how he removed the money from the post office account, Mr. Qualm was at first very hesitant to give details of how the £163,000 came to be missing.
No, it's not 163,000. It's 40,000.
Yeah, 40,277.76. So that's some extra digits and an ampersand added to that line, yes?
Which appears to be a function throughout the document.
Anyway, that amount of money came to be missing. He then gave an explanation, I think, that he would credit his A&L account number with sums of money equivalent to around £4,200 every week without putting the cash in the till. He would then use this money by means of drawing on this account by cheque payments to pay his suppliers. Yes?
Yes.
So it's the summary of what is alleged based on and only on what Mr. Qualm said.
Well, the details of the mechanics of how he went about it are based on that.
Yes. And
But-
so did you understand what's being alleged is that he fictitiously created the receipt of a sum of money, yes, into the post office.
Partly that, if we go over the page, it continues. And we can go through that if you want.
Well, let's just stick with this bit at the moment.
Okay.
So he fictitiously created the receipt of sums of money in cash, yes,
That's right.
using his post office Horizon system.
Yes.
I've received £1,000 here, £2,000 there, £4,000 there, so that on the post office account it would show money in credit.
Correct.
And then he transferred that money from what?
From his accounts to...
No, from what? How did he transfer money out of the post office account into his own bank account?
Well, the summary doesn't tell you that.
No, but okay, looking at all the papers, how did he do that?
I don't know the answer to that.
It doesn't emerge, does it?
I'm sure it doesn't.
No.
But
Because one would expect to see some document which showed the money leaving the post office account, I'm going to call it, wouldn't you?
eventually that you would have to do that to prove the case.
Yes. And you would expect to see on the Alliance and Leicester and the Royal Bank of Scotland bank statements money coming in from a post office account, wouldn't you?
You might, yes, you would.
And so that's where you would look, wouldn't you?
You would.
And did you?
I can't remember whether I did or not. The bank statements would be there. And remember, we're talking about different times. You asked me a moment ago, when I'm reading the report, do I know precisely how the money was being transferred? And the basic report doesn't tell me that. But what I'm interested in is, in broad terms, is there evidence that he's taking post office money, he's misappropriating it? And the audit seems to show that. I'm told that it does. At this stage, of course, I can't say exactly what the audit tells me.
Did you ever establish how it was said that the money was transferred from the post office account into his bank accounts?
I can't remember whether I did or not. I think maybe it might be quite...
And to be fair,
Yes.
is that because this ended up as a guilty plea?
Effectively, yes.
And therefore there was not the need for you to do that?
Correct.
I mean, is that a fair way of looking at it?
Yes. I think maybe you should also be aware of what was happening in the case. A plea of not guilty was tendered, and immediately a devolution minute was lodged, and that is a challenge to the fairness. It's a human rights issue,
Yes.
challenge to the fairness of the trial. No legal representation during the interview. Now, had
That was heard by the court
it was heard by the court.
and dismissed.
It was. Now, that was... The outcome of that would determine whether the case proceeded further. If the evidence...
Just stopping there, sorry to interrupt you. Does that mean that if the evidence which was being relied on as admissions
Yes.
was excluded,
Yes,
you had insufficient evidence to proceed?
correct.
Why couldn't you prove the case without Mr. Qualm's admissions?
Because they were one of the sources.
Yes, but why couldn't you prove the case without his admissions?
Because there wouldn't be corroborated evidence.
Why not?
Because one of the strands would be missing. For corroboration here, there are two strands. There's his admissions and there's the evidence of the audit. Take one away, it's like a bridge held up by two pillars. Audit, admissions. If one of them goes, the whole bridge collapses.
Wouldn't, if the evidence actually showed this,
Sorry, if the evidence actually
Yeah,
showed
so
what?
if the evidence actually showed the following that I'm about to outline you amount to corroborated evidence, documents from the Horizon system showing credits of cash, documents from a Horizon account showing payments of sums of money into Mr. Qualm's private bank accounts, bank statements showing the receipt of those sums of money into his private account, and then the use of those funds to pay his suppliers on the grocery business.
Correct.
That would be sufficient sources of corroborated evidence, would it not?
It would prove that money was taken from the post office, yes, for his own purposes.
Yes, that would prove embezzlement, wouldn't it?
It would.
So why was the
Yes.
why was the admission key?
Well, that would only be one source.
But you just told us that without the admission, the case could not proceed.
Correct. You need both.
Why did you need the admissions if the underlying evidence would prove the case?
It wouldn't prove the case. It would be just one strand of the case.
Okay.
Am I understanding it correctly that corroboration doesn't exist in England?
Well, there is a law of corroboration, but it's different to that in Scotland.
I think you're right to the extent that when you and I started to practice, Mr. Teale, there was a significant law of corroboration in England and Wales, but over the years it's been whittled away to be very insignificant and in most cases doesn't exist.
Almost non-existent.
Right. Thank you.
What was the point you were making there about the absence of an equivalent law of corroboration in England?
Because I get the impression that you haven't accepted what I'm saying. You haven't understood what I'm saying. And
Both of those things might be true in any given case. What I'm asking is, I understand that in fact you had two pillars:
Correct.
audit and admission.
Correct.
And you're viewing this, if admission is taken away, I've only got one pillar,
Correct.
and therefore the case can't proceed.
Correct.
I'm saying if there is all of this underlying evidence about the dishonest inflation of cash figures, the transfer of money from a post office account into a private account, and the dishonest use of that money to pay grocery suppliers, but why is that not sufficient evidence?
You'd have to then prove that it was him who had done it.
You'd have to prove that.
It was him who had transferred that money.
And so who were the other alternative people?
I don't think I can explain it very much more than I have. I'm saying in Scotland.
I think I've got the point of difference between you, but the reality, Mr. Teale, is that at the stage we are now talking about, the stage where there is evidence of an audit shortfall and evidence of admissions, if you knocked one of those out, I fully understand that even though the other one existed, that wouldn't be enough because of the law relating to corroboration. Mr. Beer's point, I think, is that even without the admissions, there were lines of inquiry which could and perhaps should have been followed, which would themselves have produced evidence, which, if they had turned out in a particular way, would have been capable of being corroboration. We'll never know because nobody followed those lines of inquiry. Isn't that it in reality?
That is perfectly right. But can I just add to that? We didn't need to pursue those lines of inquiry because we had enough corroboration given his admissions.
Yeah. You didn't need to once the judge refused to rule inadmissible the admissions.
Absolutely.
That's what you're telling me, isn't it?
Yes, that's exactly right.
Yeah, fine.
Did you read the transcript of Mr. Qualm's interview?
Have I read it?
No, did you?
Yes. At the
At
time,
what-
you mean?
At what stage of the process did you read it?
When the statements would come in.
Sorry?
When the full statements would, when the full statements and the transcription would have come into the office.
And so I think that's August 2009 we can see.
All right.
And so, again, for the purpose of the decision to prosecute, you're relying on this summary that we've just looked at, which can in fact come down from the screen.
Correct.
In his interview, Mr. Qualm raised some issues about training on Horizon. Do you recall?
Yes.
Was that investigated? Or does that fall into the same category as because you had admissions and an audit shortfall, there was no need to?
Correct.
In his interview, Mr. Qualm raised issues about seeking help from the help desk because of difficulties in the operation of Horizon. Does that fall into the same category, not investigated to your knowledge, because of the admissions and the audit shortfall?
Correct.
In the interview, Mr. Qualm identified that he had sought help in relation to an ATM error resulting in an unexplained loss of money. Same answer, same question, same answer.
Yes.
And so does it amount to this? Because there was an admission, as you saw it in interview, and because the Post Office audit...
Hold on. An admission by a letter that in his interview he had admitted writing.
Did you see this as a case that did not, in fact, require further investigation?
I couldn't have said that at the time of the report coming in. Once the devolution minute had been refused, then the case would have proceeded to trial. And it's at that stage that my investigation would have taken a more serious, in fact, a very serious turn. I would have had to have investigated everything to show the court, to demonstrate to the court what has been happening.
And so do you think if it had reached that stage, you would have then scrutinised the underlying evidence and asked for further inquiries of the type that I've mentioned to be pursued?
Yes. And I can say that having read the court minutes, I can see when the date of the
By
devolution...
minutes, just so that we all understand, that's a record in summary terms of an appearance in a court.
Correct. And to show that the debate on the devolution minute was held on a certain date. And I see from Mr. Seaton's statement that he approached me, and I suspect immediately after the court hearing, to begin negotiations, which resulted in a guilty plea. So he would be indicating at that stage that this was going to be a guilty plea.
A plea case, okay. Just on those negotiations, you were negotiating with him the amount of money that was to be said to have been lost.
Yes.
And I'm not going to go through all the correspondence, but you liaised with your post office client.
No, not a client. That's
okay, your specialist reporting agency.
Correct.
Who sought to persuade you to hold out for a higher sum of money.
Yes, slightly higher.
Yes, they wanted you to agree to state that £30,000 had been lost, whereas the proposal was £27,000.
I think the proposal was 24.
And it got negotiated up to 27.
Correct.
And is that normal that you negotiate an agreement as the amount of money that has been lost?
Yes.
And is there anything that regulates that kind of plea negotiation?
Nothing formal. Experience and good sense, and a realisation of what happens if a guilty plea is accepted which doesn't reflect the seriousness of the offence.
And for you, the difference, and for the SRA, the difference between 24, 27 and £30,000 was not sufficient, is that right, to affect the seriousness with which the court might view the offending?
Correct. I think it was the difference between 40,000, which the audit had showed as a shortfall,
Yes.
and the eventual outcome, 27,000.
And how do you go about that then? What's the thought process? Is it the evidence shows that I might not be able to prove a loss of £40,000?
No.
So why do you ever accept an amount less than £40,000?
Pragmatism, to a certain extent, a certainty of plea, a certainty of outcome.
So you can do a deal, essentially.
No, that's not the way to put it.
How would you put it then?
Well, I would put it that the fiscal is always considering whether you're going to cause difficulties for the sheriff, for the judge, when it comes to sentencing. I mean, if I were to accept a plea of guilty to £5,000, that would have been a considerable difference. As it stood, the difference between 27 and 40,000 would really not have affected his sentencing powers. If he had wanted to send Mr. Quorum to prison, he could just as well have done it on the basis of 27,000 as 40,000.
Thank you. Mr. Teale, they're the only questions I ask. I think there are some questions from Mr. Steen.
Mr. Teale, I've just got a few questions for you. I represent sub-postmasters and mistresses. I'm instructed by a firm of solicitors called Howe & Co. Okay? Can you just help me with a little bit by way of the procedure in Scotland? You were appointed the Procurator Fiscal for the jurisdiction of the Western Isles. Is that correct? In 2000?
Yes,
And you left that post in 2015?
yes.
Okay. Above you, in terms of the system, who would be the next person, if you like, as a line manager? Would that be the Lord Advocate?
Oh, no, no, no.
No. Okay. Help us, please, with the system going up hierarchically above you.
Above me directly would be the Area Procurator Fiscal, and that would cover the whole of the Highlands and the Islands. And above him would be a Deputy Crown Agent, I presume, and then after that, Crown Agent.
Okay. So your work as the Procurator Fiscal for the jurisdiction of the Western Isles, would it be fair to say that operationally you were in charge of prosecutions within that area of the Western Isles?
That's correct.
Right. So Mr. Beer has examined some of the material in relation to another statement that deals with the question of contact from the Post Office with the Lord Advocate's office, yes?
Yes.
Okay. Would it be fair to say that any issues that may have had an impact on your decision-making for prosecutions within the Western Isles area should have been therefore provided to you? So, shall I try that again?
Please.
All right. If the Lord Advocate's office is provided with some information about issues that related to the prosecution of post office cases,
Yes.
should that have come down to you?
Well, it would depend entirely on what the information is,
Yeah.
and whether the Lord Advocate thought it appropriate that Procurator Fiscals on the ground should be aware of it.
Right. Well, if it is of the nature of information that relates to, say, the reliability of the Horizon system, should that have come to you?
If it's at the level that the Lord Advocate has indicated that it was, yes, and I understand that it did come down.
Right. did it come to you? Mr. Beer asked a number of questions, and you've used the term, many a time, you used the term, I can't recall, I can't remember.
Yes.
Did it or did it not come to you?
How can I answer that? I can't recall whether it did or not.
Right. So it's a lack of recollection.
Correct.
Right. So you're saying essentially you do not know whether or not it was sent to your office?
Correct.
Okay. How do we check?
I suppose your first port of call would be Crown Office.
Okay. Right. Now, moving on to post office cases. So concerning the prosecution of sub-postmasters, mistresses, managers at post offices and employee staff at post offices. Okay. In police cases, you get information from police officers, is that correct?
They're often the reporters of cases, yes, reporting officers, yes.
Because in police cases, the police themselves are the investigators, they're the reporters, normally to your office when you were in charge at for the Western Isles as a procurator fiscal. Is that correct? Okay. So with police cases, you've got a basic understanding that these are police officers who have been trained in their job. Is that correct?
Correct.
They've been trained in the work of an investigator. Is that correct?
As far as I know, yes.
Yes. Well, when you say as far as you know, shouldn't you, Mr. Teale, because of your work?
They are.
They are, precisely. And you're also aware that, therefore, their training will include how PACE works, yes? Police and Criminal Evidence Act.
I don't know if that applies in Scotland.
All right.
I think there's an equivalent.
Equivalent in Scotland. The system of prosecution, the checks and balances in relation to the collection and presentation of evidence.
Yes.
Okay.
I think it's a 2010 Act.
Okay, I'm very great.
Regulates that.
And also you're aware that as regards to the police, that they have systems in place so that they have operationally, there are police officers, there are sergeants, inspectors. There's an entire system of checks and balances in relation to police work. Do you agree?
I'm not certain that would be checks and balances, but there is that range of authority, yes.
Okay. Now, as far as you can recall, were you ever given any information about the training and experience of post office investigators?
No.
As far as you can recall, was there any protocol or guidance as to how your office should deal with post office cases?
There was guidances from COPFS to the reporting agencies indicating what COPFS required of them by way of reports and investigations. Does that answer you?
Perhaps it does. Did that guidance go to the question of the quality of the information that was being provided? Do you recall?
Yes, in fact, I think the document we have here, it was provided to me yesterday, I think.
Just helping one step further, if we can, please. In relation to the post office, do you agree that one of the factors that's different to the police cases for the post office is that the post office cases, the post office is the victim?
Yes.
Did you ever give that any pause for thought and think to yourself, have we got something here in relation to post offices that is different from, say, a police case?
Yes, it's certainly something that, yes, I have considered. It's a commercial organisation, and that has been apparent to me throughout my career. Other reporting agencies have got their own priorities, like DWP, loss of funds to the public purse. But yes, you're always considering that. Whenever you're looking at a case, is there any reason to suspect that something might not be as straightforward as it appears?
And as you say, in relation to a commercial organisation, something like the Post Office, which also has a reputation to uphold,
Yes.
how would you apply that thinking to the analysis as to whether a case should go ahead?
You're deciding on the basis of the evidence that's being supplied to you. And I suppose if you had some doubt that it was being manipulated or that it wasn't accurate, you would be very careful about proceeding.
Now, Mr. Teale, you held a senior position in the system of prosecutions within Scotland for many years. You must have been following the progress of the proceedings in relation to Post Office cases. First of all, you're aware that 555 individuals took on the Post Office in the High Court. And secondly, after that, in the Criminal Court of Appeal, the Criminal Court of Appeal in England and Wales overturned many convictions later on. You're aware that in Scotland, its own procedures are taking place in relation to convicted individuals. And finally, of course, here you are at the Post Office inquiry giving evidence in relation to your recollection of events that you were party to in Scotland when you were in post. You know now that defects, errors, bugs were found within the Horizon system. As we understand your evidence, you were never told about those bugs, errors or defects. Is that correct?
I can't recall being told about them.
Do you think you would have recalled if you had been told?
I can't say.
What do you think now about the fact that, as far as you know, you weren't told about bugs, errors and defects within the Horizon system? Do you think that that's a matter that is of any concern to you now?
Being told by COPFS.
Well, being told by all of the events that I've just described that have taken place, the judgment in the High Court, the judgment in the Criminal Court of Appeal, the sheer fact that we're at the Post Office Horizon in IT inquiry, does it give you any cause for concern that you weren't told, it seems, that there were bugs, errors and defects in the Horizon system?
Well, I think the Lord Advocate made the position quite clear. And really, I don't think I can say anything further than that.
Do you think it would have been a good idea for your office to have been told about those bugs, errors and defects, Mr. Teale?
I don't know.
Thank you, Mr. Teale.
Thank you.
Anyone else?
No, I don't think there is, sir.
Right. Well, thank you, Mr. Teale, for providing your evidence in written and oral form. Just in case I wish to become a little better acquainted with the Scottish law of corroboration, I'm not saying I will, but just in case, am I right in assuming that it's part of the common law of Scotland? It is not based on a statute?
I think that's correct, yes.
So that if I wanted to have a greater understanding of how it operates, I'd probably need to look at a few leading cases from the High Court, yeah?
Stretching back many years, yes.
Yeah, fine. All right. Thank you very much.
Thank you.
Mr.
Thank you.
So if it assists, that you are right in that belief, and indeed there have been, I wouldn't call it watering down, but there have been tweaks made to the approach to corroboration by the appellate courts in Scotland over time.
Yeah, well, since we're not rushed for time today, I did notice that in the most recent prosecutor code you showed, Mr. Teale, the word in general was used in advance of corroboration being necessary.
Yes.
So it looks as if there are some tweaks, as you say. Fine. All right then. 10 o'clock tomorrow morning?
Yes, please, sir. Thank you.
Fine.